Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. I know there are some of you that like the fact that half my mustache is white and half of it is not. Nothing I can do about that. I'm not going to shave my goatee. The reason for the goatee is, well, quite frankly, I prefer it. There's also some scarring that it covers, which is the reason for the loss of pigment. However, it doesn't matter. If you don't like it, you don't like it. You don't have to deal with me. I color it when I have trial because, well, quite frankly, it can be a distraction. So, that said, today I want to talk to you about a very popular topic that people get wrong constantly on Facebook and on Reddit and other groups and organizations. It has to do with medical marijuana and your firearms rights. First, let's address federal law. And this is something that nobody likes. They don't like the fact that the law is rather clear and no, you cannot have guns. Now, I'm not saying that it's limited to the buying and selling of firearms, because that's not what I said. There are two sections in 18 U.S.C. 922 that you have to pay attention to. Okay? The first deals with transferring of firearms, and that's the one that most people are worried about. You're not going to be able to go and purchase a new firearm because while you have your medical marijuana card, because you are presumed to be a user or addicted to a substance that is on a controlled substance schedule nationally. You are not going to be able to purchase from that dealer, or you're going to falsify your form and you're going to face some pretty serious penalties, up to and including jail time. So a lot of people said that you can still purchase a private party, and yeah, private sales can and will happen, but there's a second clause in 18 U.S.C. 922 that outlaws the possession of the firearm by a person who is a user of illegal substances, controlled substances, or addicted to them. So let's talk about reality for a minute. While yes, that is outlawed, it's illegal. What is the reality and the possibility that you're going to be charged with it? Well, it's very low. The FBI isn't out trolling to see who smokes a dime bag on the weekend and has a hunting rifle. They're not going to give a shit about that. What they are going to do is, if you're getting swept up for something and they can drop another charge, they'll add it. It's part of the leverage they'll use to get you a plea. So that is the reality of that. The likelihood of being charged as a standalone charge is very low. However, it is a misstatement to say it is non-existent. Okay? So you're going to make your own decision on that. If you're going to have your medical marijuana card and you're going to run around with a shotgun in the back of your truck, or have your 45 strapped to your waist, that's up to you. You're going to make your own decision. But the people that are telling you that that is absolutely legal are absolutely wrong. Will you be charged? Probably not. It's a low chance, low probability of actually being charged for it. But it exists. In the state of Missouri, however, if you are under the influence of your medication or alcohol and you are using or possessing a firearm, you are wrong. You very likely could be charged. Well, you could be charged, and in some areas it's very likely that you would be. Does the officer have discretion? Yes, of course they do. And the officer may not fill out a report and pass out to the prosecutor. And congratulations, I'm happy for you if that's the case. But they might. That is their choice. And when you're dealing with somebody's choice, you know, how much of a dick you are on the side of the road is going to make a big factor in whether the cop tells you to go home or he takes you to your new residence. So think about that, and please don't be jerks to cops. Most of them don't deserve it. But you cannot possess a firearm while you are actively under the influence of a mind-altering substance. Marijuana is a mind-altering substance. Okay? Here's the fun part. Are they going to be able to actively prove that you were intoxicated at 3:55 p.m. when they arrested you? That's a much, much harder case to make. Okay? And they will have a hard time doing that. However, I've said this before, we have a statute that prohibits possession of a firearm by people who are habitually in a drugged or intoxicated condition. That is a statute that hardly ever gets used. By hardly ever, I mean, when I looked it up, and I didn't look it up for today, last time I looked it up, there were no appellate cases on it, on that statute. And it's because, I mean, how do you prove somebody's in a habitually intoxicated state? Well, chances are, if they're habitually in an intoxicated state, you caught them drunk with a gun, you charge them with that, and you move on. You don't file the esoteric charge just because you can. Prosecutors don't like creating useless work for themselves. And habitually in a drug condition, you know, that's a much tougher one to make. Okay? How do you prove somebody is in a habitually drug condition? Well, it's a lot harder before you registered with the state and got your medical marijuana card, and the state has records of how much medical marijuana you're buying at the local dispensary, because that's all recorded. Let me repeat that for the people who don't understand this. Well, they can't tell how much I'm actually smoking or if I'm smoking. No, they can tell how much marijuana you're buying at the dispensary, because that record is maintained in the state database. Okay? Seed to sale tracking. They're going to track the sale of the medical marijuana. The next response, well then fine, I'm just going to be a home cultivator. Okay, great. Be a home cultivator. The net result is still somewhat similar. They have you in a state database identifying yourself as a person with a medical marijuana card that is using medical marijuana for your illness or injury or whatever your medical condition is. And it is so bad that you grow the stuff at home. Again, a habitual drug user, yeah, I think there's a pretty valid argument that can be made there. So you got to be careful with that. Now, is that saying that the local sheriff, when you get your medical marijuana card, is going to come kick your door in and confiscate all your firearms? No, that's not going to. That is very unlikely to happen. Does that mean that if they come out for another call, they see that you have a medical marijuana card, they happen to see that you have a secure room where you have identified as your grow area, and you have a shotgun, a pistol, and an AR in the living room? Now, might they look at that? Well, yeah. Now, let's add in what might drive a police officer to to pass that probable cause statement on to the prosecutor? Well, if you're standing in the living room and you're screaming at him because he's a jackbooted Nazi thug, yeah, the odds are probably a lot higher that he's going to find something to charge you with if you're being a jerk. So the essence of this is that you are in an area with unsettled law, and it is in your interest to learn how to assert your rights without becoming a jerk. And you can assert your rights without calling the officer every name under the book. And we can talk about that in another video, and maybe we should. You know, how to go about and assert your rights. But understand that the issues that you have here are, there is a lot of misinformation out there. And people will focus on one part, that the sale is illegal under 18 U.S.C. 922. However, in a later paragraph of 922, possession is illegal as well. And that's something to be aware of. Are they going to charge you? Shit, man, probably not. I doubt it. As far as state law, you know, you're talking RSMo 571.070, section 2, one of the clauses under paragraph 2. So that's, have they charged it? Yeah, I don't know. Appellate cases? No, and I would think that a defense attorney would fight that, because that's a tough evidentiary question. So, does that mean that they can't? Certainly not. Of course they can. Can they charge you with possessing a firearm while you are in an intoxicated condition? Definitely. So if you're sitting in your house and you are baked, and that's when the cop comes and knocks on the door, and your firearm is sitting on the countertop right in front of you, or on the coffee table rather. He comes in, he's talking to you. You're not in trouble for being baked, you got your medical card. You're not in trouble for smoking marijuana, you got your medical card. You're not in trouble for possessing it, you have your medical card. But you got a pistol right in front of you that you have possession of. That you could very well be in trouble for. So, you have to use a modicum of common sense. If you're walking around with a baggie of weed, and you can possess up to 4 ounces, up to 8 ounces, 2 months, 60 days, you can possess that with your medical marijuana card. I wouldn't recommend it, you know, small amounts, but you can. Now, if you're also going to strap on, you know, your 1911 or your Glock 21, well, the officer might take a different view of that. Is he right? Is he wrong? You know, we don't know where that's going to go yet. We don't know how the court's going to rule on a lot of these questions. Possessing a firearm and illegal substance at the same time? Yeah, you're wrong down the line. But is your substance illegal? Well, just because you have a right to possess that much, does that mean you have a right to walk around with 8 ounces in your pocket? Because that's still questionable. Do you need to carry everything you have with you? Or are you coming back from purchasing it? You know, again, these are all discussions that we just don't have answers to. And we're not going to until the court hears a case and rules. The problem with being the first case, it may not go your way. So don't be the test case. Don't be that person. Be smart, be safe. You know, I'm not saying you need to get rid of all your firearms. I would say if you called and you asked me, we would talk about it, and I would give some legal advice that would be something to the effect of, you probably don't want it in your possession while you're under the influence. I would say no. Use a gun safe. As for whether or not you can own that firearm and your medical marijuana card, we don't have the answer to that. I can't tell you the court's going to rule. I would opt on the side of safety. Okay? I would relocate those firearms away from my medical marijuana. I know that's not the answer a lot of you want, and I'm going to get thoroughly castigated in the comments. I want to hear what you have to say, but please don't be the test case. Let somebody else. Hit like, subscribe, follow us, drop comments. I got to tell you, YouTube will respond to the likes, the subscriptions, and comments. And we respond, when we can. If you're just commenting to call me a name, hey, I'm glad you commented, but I'm probably not going to respond yet. If you've got a serious question, we'll chat. I like the dialogue. But I cannot provide legal advice through a comment forum, and I won't do it. This is for entertainment value, and I'm not representing you. Thank you very much, and we'll be talking again soon.